way we will see where we are going. So we are going to begin with the bills on retirement system. Ms. McCarthy-Reed. And so I will sorry, my screen keeps blinking behind everything else.
Now when you're ready.
Yep. What are the numbers for those, Ms. McCarthy-Reed?
The two retirement bills are LD 397 and LD 509.
Okay, they are the first two ones. All right, great. Thank you. I don't know why it just keeps slipping behind the Zoom screen here.
Sure.
So I will open the work session on LD 397. Ms. McCarthy-Reed, if you could give us the analysis.
Sure. I'm going to share my screen.
And you can give us the quick version, because as we've already discussed, I want to make sure that everyone understands that we have kept a bill to be an omnibus bill, that we are going to discuss these bills in their totality, but we would like to hear the analysis of it.
Sure. I think I'll just do it verbally, then share the screen. We've been using a chart to sort of keep all the retirement bills together. In LD 397 is an act to recalculate retirement benefits for certain state employees adversely affected by merit pay increases. So the bill as drafted is a piece of legislation that was considered by the committee last session. And it's been reintroduced this session because it wasn't finally acted upon. But as it's drafted, it would authorize members of the main employees retirement system who retired on or after May 1st of 2014 and prior to June 30th, 2014, to include in their retirement benefit calculations of wages lost to merit pay freezes retroactive to the date of their retirement. So as you heard at the public hearing on this bill, there were some merit pay freezes implemented as part of some legislative changes in 2011. And so for this bill would allow those members who retired and were subject to some of those merit pay freezes, and it affected their calculation of their average final compensation for retirement purposes. This would allow those members within that time period I mentioned to have that have the amount of those wages lost accounted for as for their retirement benefits. An initial estimate we received from Maine PERS does indicate that there is an unfunded actuarial liability associated with LD 397 if it moves forward. And they've indicated that it would be a one-time general fund appropriation of $600,000. I think I'll stop there. I'm happy to talk with you further if you'd like, or ask any questions about this legislation.
No, I think that is great. Is Representative Pickett here? I do not see him. Okay, so as we discussed, and so this will be for Representative Dodge's bill as well. This committee has decided that these retirement bills really need a strategy going forward, that it doesn't make sense to keep moving bills forward out of committee that we know can't be paid for, and to try to come up with a plan to do so. There, we are reaching a point where the unallocated funds are going to be hitting their end, and money might become available to pay for some of these lines that have been drawn in the sand where people end up on one side or another. We don't know how all that work is going to end up or where the committee will decide to be, but we have chosen Representative Doerr's bill to move forward, as that is the bill that is Representative Doer, as a past member of this committee, has been fighting for these issues for many years, and it seemed and has a title that can fit all of these issues that we are talking about. So, with that, is there any discussion, or I'd be open to a motion? Senator Merrimont.
Thank you, Mr. Chair. It's always hard to have your bill fail. I've had a few go this year, and I hate that, but I do respect that we are doing the work and that many voices got to weigh in this time. So I move this bill ought not to pass.
The motion is ought not to pass. Is there a second? Seconded by Representative Pebworth. Is there any discussion of the motion? Seeing none. Ms. Thompson, could you call the roll? And if everyone could turn on their cameras so we're present.
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin.
Yay.
Guerin, yay. Senator Miramont.
Yay.
Miramont, yay. Representative Sylvester.
Yay.
Sylvester, yay. Representative Bradstreet.
Yes.
Bradstreet, yes. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
Yay.
Drinkwater, yay. Representative Gear is absent. Representative Morris.
Yes.
Morris, yes. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott.
Yes.
Prescott, yes. Representative Rader is absent. Representative Warren.
Yes.
Representative Warren, yes. That is unanimous of those present.
The roll being unanimous of those present, the motion prevails, and I'll close the work session on LD 397 and open the work session on LD 509. And if we could have a similar
Quick.
verbal walkthrough, yes.
Sure, I'll do this quickly as well. LD 509, this was a bill sponsored by Representative Dodge. It's an act to protect teachers from a decrease in retirement benefits arising from the COVID-19 pandemic. The bill as it's drafted would allow teachers nearing retirement who have experienced a reduction in income from the elimination of an extracurricular or co-curricular position due to circumstances related to COVID-19 to purchase service credit in the state retirement system for that period of income loss due to the loss of that stipend. The bill as drafted would allow the individual to purchase service credit to cover that lost income. I should also note that there was an amendment presented that I shared with you earlier that would clarify that in addition to being able to purchase the service credit, the intent was that it would also include that amount of lost income in the calculation of a teacher's average final compensation. So that's LD 509. And again, the period in the bill that was proposed to sort of cover the potential for a lost stipend was January 1 of 2020 to July 1 of 2022. And the amendments, as I understand it, would shorten that time frame from January 1 of 2020 to July 1 of 2021. You don't yet have any fiscal information related to LD 509. I mean, the original bill, the intent was that it would have no fiscal impact because the cost to purchase any service credit would be on the individual teacher or member taking advantage of that opportunity. And then they have not yet determined any potential impact of that additional amendment I mentioned, which would include the amount of that lost income in the average final compensation. That's still to be determined.
Would we assume that shortening that would lower any fiscal impact?
If there was any, yes, I think that's correct.
I'd like to call Representative Dodge forward and to discuss her amendment a little bit and some of the negotiations that got us here, because I understand that there's been some negotiations with MEPERS on this. And I'll just start with, is my assumption correct? Should there be no fiscal note on this, and will the amendment actually lower any impact there might be?
That is correct as far as I know. That is the intent. And I would ask if you could perhaps call in Mr. Kaczynski from the Maine Education Association. He, I believe, has the latest update from MEPERS.
Is there anyone from MEPERS here?
Mr. Colleran is here from Maine PERS. If you wanted to recognize him, I know.
I would like that. Mr. Colleran, could you come in and speak to this issue?
Yes, good afternoon. Our understanding is, I haven't seen the draft amendment language, but our understanding is that there's no fiscal impact from this because the cost would be borne by the member.
Okay, thank you. So I'm going to open discussion. I guess the question is whether or not this bill is different than the bills which come on with an unfunded liability, and if we want to treat it differently. So I would open that to discussion to the members of the committee, as there's no fiscal impact to it. Representative Drinkwater.
Thank you, sir. We just heard from MEPERS that they understand it. And even though they haven't read the amendment, apparently, that there's no fiscal impact. I'm assuming that it will come back for language review. And if there's a fiscal impact statement, it would come back at that time. And is that all true?
Yes.
I certainly believe it to be true, yes.
I'm happy to share the amendment as well, if you wanted to pull that up on the screen, but
Could we see that, please?
sure. I think you can see this now. This is the draft amendment, and what the amendment does is it adds in section 1, which is here's the language that relates to how someone's average final compensation is calculated. It would add language underlined here that if a member of a local school administrative unit lost income from employment during that period, January 1 of 2020 to July 1 of 2021, and the member elects to make payments, which purchases the service credit, then that amount, they're entitled to have that amount included in their average final compensation. Section 2 of the bill makes clarification, additional clarifying language about how someone adds additional references in another section of the statute, again, to that lost income. And then section 3 of the bill is the provision that was included in LD 509 as it was drafted, with which is the authorization for those members to purchase service credit, with the change in the time period that I mentioned, limiting it to the period between January 1 of 2020 to July 1 of 2021, and the teacher would be in their final 3 years of service during that time period.
Thank you. I personally just want to laud the sponsor in being able to work this without a fiscal note. Is there any discussion? Representative Bradstreet.
Yes, thank you, Mr. Chair. And thank you, Representative Dodge, for working on this. I just want to be clear that not only is there no fiscal note for the state, there are to be no ongoing or future costs, additional costs for the local school district. Is that correct?
That's my understanding.
Okay, good. Thank you.
Is there a motion? Representative Drinkwater.
Well, seeing how she's such a good friend of mine, we served in education together. I'd like a motion ought to pass.
The motion has been made to pass by Representative
As
Drinkwater.
amended?
Is there a second?
Yes, as amended.
I think. Thank you.
Yes.
As amended, thank you.
Great, thanks.
Is there a second? Representative Warren. Ms. Thompson, if you would, is there any discussion on the motion? Are your hands up, gentlemen, from before? Representative Bradstreet, Representative Drinkwater? Okay. Very good. Ms. Thompson, if you would take the roll.
Mr. Chair.
Oh, yes.
Yeah,
Mr.
no,
Chair.
I never have to raise my hand. I can't find the function. I just wanted to say that given where we have been and where we're trying to go, and it looks like this committee has come together, it wouldn't be possible without the great work of Representative Dodge. So I just wanted to appreciate and compliment that, because again, this is labor and housing. And sometimes we don't agree on much, but here we go. So thank you.
Thank you, Mr. Chair. Is there any other comment? Ms. Thompson, if you could take the roll.
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin.
Yes.
Guerin, yes. Senator Marymount.
Yes.
Marymount, yes. Representative Sylvester.
Yes.
Sylvester, yes. Representative Bradstreet.
Yes.
Bradstreet, yes. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
Yay.
Drinkwater, yay. Representative Gear is absent. Representative Morris.
Yes.
Morris, yes. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott.
Yes.
Prescott, yes. Representative Rader is absent. Representative Warren.
Yes.
Warren, yes. That is unanimous of those present.
The roll being unanimous of those present, the motion carries, and would close the work session on LD 509. And Representative Dodge, give you the last word.
Thank you so much, Mr. Chair. I cannot tell you how appreciative I am for the number of people who will receive just a little bit more in their retirement compensation for the vote that you have just taken. I thank you deeply.
Thank you, Representative, and we thank you for your great work on this bill.
Thanks.
I'm going to go a little bit out of order to a bill that is similar to one we've already heard and open the work session on LD 1339, an act to clarify that municipal firefighters, volunteer first responders, and substitute teachers are excluded from Maine's earned paid leave, brought forward by Representative Randall Green of Wales. Steve, if you would give us the analysis.
Greenwood, Representative Greenwood.
Greenwood, I'm sorry. I
Hold
had to
on.
clean my glasses.
Let me pull up my analysis. Okay. So this bill excludes from the law requiring employers of more than 10 employees to provide earned paid leave to municipal firefighters, volunteer first responders, and substitute teachers. There were a lot of suggested amendments at the public hearing on this bill. One was to extend the exemption to all municipal volunteers. Maine Municipal Association recommended firming up the definition of firefighter. Maine Ambulance Association recommended that an exemption be extended for per diem emergency medical services personnel who are not obligated to work a set schedule. And the Maine Town and City Clerks Association recommended the addition of election clerks to the exemption. I wanted to note, as Representative Sylvester alluded to, the committee did take up LD 838 by Representative Poirier, and a minority of the committee voted on to pass as amended on April 23rd of that bill. And subparagraph 2 of the amendment does exempt a volunteer and a person who is paid a stipend by an employer or who works for an employer on a per diem basis. And I know in working with the language with the sponsor, Representative Poirier's intent was to cover any volunteer, any person paid a stipend by any employer, or anyone who works for an employer on a per diem basis in a municipal setting. So I believe that this language captures what the intent of Representative Greenwood brought forth at the public hearing on LD 1339. I'm happy to work with the Department of Labor, and I have had some conversations with them to ensure that the intent was captured. The department did testify, as we heard on the other bill, that the earned paid leave law is cross-referenced directly to Maine's employment security law, which we got very familiar with today. And the department is fully able to interpret and enforce it. And they also said that it's premature to consider exemptions at this time because an annual report is not due to this committee until January 1st of next year. And perhaps it makes sense to consider exemptions at that time. And I would note that Representative Greenwood asked to have several folks from his community here present for the work session. And we did actually receive a preliminary fiscal impact statement on the bill as drafted, and there would be no state fiscal impact. So there would be no fiscal note required if it was a straight on to pass.
Thank you, Mr. Langland. Is there any discussion from the committee? Representative Bradstreet.
Yes, thank you. I'm just wondering if the sponsor would want to chime in on anything here, if he's happy with the bill as he presented it.
Thank you, Mr. Green. Representative Greenwood, if you want to come forward.
All right. Thank you, Chairman Sylvester. I just wanted to make sure I understood what I received this morning from Mr. Langland, who just spoke, was the minority. There was a minority report that included this language. So this language currently that he sent is not in statute, correct? Okay.
That's correct. Yep.
Yeah, I just think we need to incorporate this into statute. I mean, the Department of Labor has been giving very, unclear opinions as to who's covered, who's not. Apparently there was some employment security discussion today that I wish I could have participated in, but I didn't. But I really think that we need some clarity on this. So.
Thank you, Representative. Is there any further discussion? Seeing none, I would accept a motion. Representative Bradstreet.
Thank you, Mr. Chair. I move ought to pass.
The motion is ought to pass. Is there a second? Representative, but seconded by, I see Representative Morris, and he doesn't second very often, so I'm gonna pick him. Is there any further discussion? Well, I'll just say that for myself, in the 129th, right after we had passed all of the minimum wage bills, in the 128th, there were a slew of bills to affect that new law that had just come into effect in many, many ways. Some of them I agreed with, some of them I didn't. I voted them all the same way. I voted against them because we didn't have time yet to see how the law would affect Mainers, Maine businesses, Maine workers. And at the same time, I pressed very hard to make sure that we would get info about those things. And so, so in this case, where no one has actually even begun to receive any benefits from this new law, I would be very reticent to go pulling folks out without knowing exactly how it's all going to play out. But that's my own personal opinion. And I see that Mr. Langland has his hand up.
Yeah, I just wanted to clarify. So the motion's just straight ought to pass as it was originally drafted. Is that what the motion? Okay.
Representative Bradstreet.
Thank you, Mr. Chair, and I appreciate your perspective on that. I see it a little bit differently. I think it's expanded, the pay time off is expanded a little bit beyond what we originally intended. And I do think that we don't have to wait to see how things are going to go fiscally for some people or some places. We've already heard from people that said, this is going to adversely affect our budgets. And those people work with budgets year in and year out. They know what's going to happen. They know what the extra costs are going to be. So that's why I'm going to be voting to support the motion. Thank you.
Thank you. And Representative Greenwood, I see your hand, but we have a motion on the floor. So it's past time where I'm going to call on folks besides committee members. Is there any other discussion? Ms. Thompson, if you would take the roll.
Senator Hickman.
Nay.
Hickman, nay. Senator Guerin.
Yes.
Guerin, yes. Senator Miramont.
Nay.
Miramont, nay. Representative Sylvester.
Nay.
Sylvester, nay. Representative Bradstreet.
Yes.
Bradstreet, yes. Representative Cuddy is absent. Representative Drinkwater.
Yay.
Drinkwater, yay. Representative Gear is absent. Representative Morris.
Yes.
Morris, yes. Representative Pebworth.
No.
Pebworth, no. Representative Prescott.
Yes.
Prescott, yes. Representative Rader is absent. And Representative Warren.
No.
Warren, no. Of those present, that is 4 in favor of the motion and 5 in opposition.
The tally being 4-5, the motion fails. I would take another motion. Representative or Senator Miramont.
Yes, Mr. Chair, move ought not to pass.
The motion is ought not to pass. Is there a second? Seconded by Representative Warren. Is there any discussion? Seeing none, Ms. Thompson, if you could take the roll.
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin.
Nay.
Guerin, nay. Senator Miramont.
Yay.
Miramont, yay. Representative Sylvester.
Yay.
Sylvester, yay. Representative Bradstreet.
Nay, and I would question the previous vote too. I thought we had 5 in favor. That's all.
Oh, no, yeah, you're right. I apologize. You're absolutely right, actually. That's my bad.
All righty. Well then, let's roll things back. Then we have a provisional passage with absent members. So I believe, Senator Hickman, if I'm correct, that and Mr. Langland, that we need to wait for those absent votes to come in to finish the tally.
Well, if the motion was 5-4, then the motion prevails, and
So the motion, right? And
the previous motion prevails. So
right.
at that time, it means that motion prevailed. So the auto-pass motion prevailed, and then people who are absent from that vote have until the second day to cast.
That's what I'm saying. So the motion prevails, barring absent votes. All right. Excellent. Then I will close the work session on LD 1339. And I'm inquiring, I was looking to see for who was amongst us for sponsors, and who were not on the committee.
I see Representative Bryant.
Representative Bryant, okay. Then I will, Representative Bryant, could you come forward? Thank you, sir. Then I am going to open the work session on LD 1430. And if we could get the analysis on that.
Sure. This one is mine. It's a workers' compensation bill, so I'm going to share the analysis. This is an act regarding the waiting period for compensation for incapacity to work under the Maine Workers' Compensation Act of 1992. The bill as drafted would amend the Workers' Compensation Act in Title 39A by allowing an employee of a state or county who is employed by a correctional facility and an employee of a county or municipality whose place of employment is a county or municipal detention facility to receive compensation from the date of incapacity. It also would allow certain employees of a state mental health institute incapacitated because of an infectious disease or an assault by a resident of the institute to receive compensation from the date of injury. The general rule in the Workers' Compensation Act currently is that there is no compensation for an employee for the first 7 days of incapacity. If incapacity continues for more than 14 days, the employee is entitled to compensation for the incapacity dating back to the start of that incapacity. There is one exception in the current law. Firefighters are entitled to compensation for incapacity starting from the date of incapacity, regardless of how long they are incapacitated. And so the current law, the statutory provision is there in the italics for you. I also provided a link to the written testimony. Proponents of the bill noted that employees in correctional facilities and certain employees of state mental health institutes have dangerous jobs on par with firefighters. They noted that these workers must use their personal leave time if they are unable to work during a period of incapacity that's less than 7 days. And if their incapacity is less than 14 days, they are not entitled to compensation from the date of incapacity. You did have some concerns raised in testimony from the Maine Council of Self-Insurers, opposed to the bill, concerned about the bill creating special privileges for certain groups of public employees under the Workers' Compensation Act. You've heard these concerns raised before when you considered previous bills expanding the rebuttable presumptions that are available under the Workers' Compensation Act. They thought that this might have the potential to bring forward other groups if you make an additional exception to ask for the same change as is proposed in LD 1430. You also did hear some testimony, had some testimony from the Maine County Commissioners Association that I wanted to note, raising their opinion that the bill would constitute a mandate. We have not yet received the information from the Office of Fiscal and Program Review indicating that the bill is a potential mandate, and so would trigger the further decision-making by the legislature about whether or not to add a mandate preamble or to appropriate funds for those additional costs. But they also noted that statutorily, Maine counties cannot increase their jail-related costs above a fixed level set by statute. And for those county jails whose expenditures might be at the statutory cap, any new expenditure must come from the state or from an offsetting reduction in their services if the passage of LD 1430 does lead to increased costs. As I mentioned, the bill as drafted does not limit the type of incapacity for a corrections employee, but it does appear to limit the type of incapacity experienced by an employee of a state mental health institute, incapacitated because of an infectious disease or an assault by a resident. So I just wanted to point out the difference in treatment between those two categories of employees. And then also the definition of infectious disease in the bill is broad. We talked about this previously when you discussed Representative Pebworth's bill that created a rebuttable presumption related to infectious disease. So I just raised that for you. And then a technical change, if the committee does move forward, the language in the bill refers to a state mental health institute. And I think it's more commonly found in the statute that the reference is state mental health institution. So I think I might suggest that as just a clarifying technical change if you move forward. And then the committee did ask for some information about the legislative history of the waiting period in statute and in workers' compensation, as well as the exception that's currently provided by firefighters. I did want to note that Section 204, which I just showed you previously, was enacted as part of the 1991 workers' compensation reforms, and it was as it's currently written. So that exception with regard to firefighters has been in statute since those comprehensive 1991 reforms, and the legislation has, or the section 204 has not been amended by the legislature since 1991. I do know Mr. Rohde is here from the Workers' Compensation Board, and if the committee is interested in sort of discussing and going back even further of the legislative history of waiting periods, he could respond to some of your questions.
Thank you, Ms. McCarthy. All right, thank you, Ms. McCarthy-Reed. Is there any discussion? Senator Marymount.
Great. I'll make a motion not to pass with the change that mental health workers are not treated differently by the language as for differently than firefighters, and that the term state mental health institute is used as suggested. There may have been a third one just above the pointing out that the mental health workers language was different than firefighters. I didn't catch that to write it down. If you could share your screen or if someone else knows it, I'm open to adding that change that may have been necessary. Actually, it may not have been. No, it wasn't. Never mind. It was about the counties, and they can deal with that and come back to us. So that's my motion with it amended as stated. If you need me to repeat it, I could bumble through it again.
So as I understand, the amendment is to have corrections officers treated with the same exception as firefighters and with the language correction that Ms. McCarthy-Reed made.
Was it corrections workers or mental health workers?
Oh, I'm sorry, mental health workers.
Thank you.
Long day. Yep.
And state mental health institution. Yes, that's correct.
Is there a second? Second by Representative Cuddy. Is there any discussion? Chair Hickman.
Yes, thank you, Mr. Chair. I guess I do have, I'd like to know the intent of the bill sponsor around infectious disease. The common cold is an infectious disease, and I can't imagine that the intent is to have that included, but the definition would include the common cold in this. So I'm wondering if Mr. Representative Bryant can sort of tell us if there's any limiting language around that definition that we can consider as a friendly amendment.
Representative Bryant, you should come forward, please.
Thank you, Chair Sylvester and Chair Hickman. My intent was mainly the pandemic, when we had something so infectious that was going to take over you, and that was mainly was the COVID-19 disease at the time, something that was going to incapacitate you, something that was going to be given to you.
So
common cold, in my opinion, was not anything I had thought of, and I'm not a doctor, and it's out of my field, but it was going to be something in my mind egregious that what as opposed to a common cold.
So if we vote this out with this amendment, would you be willing to work with the committee on well, we can do it today, but I think that we need some language that limits infectious disease to something along the lines of what you just said, which is something debilitating or has the ability to incapacitate for a significant period of time. We need more definition to make sure we're not including the common cold. So would you be willing to help us limit that language if we pass this out today?
Absolutely.
Okay, thank you.
Thank you.
Ms. McCarthy-Reed, could you go over what the firefighters, what that exemption is, so we're clear about all of the things that are covered in that?
Yeah, under the current statute, there is no distinction in the language as I read it. It just says that compensation for incapacity to work is not payable for the first 7 days of incapacity, except that firefighters must receive compensation from the date of incapacity. So my understanding, actually, I was going to ask a question of Senator Miramont's amendment, was to remove those parameters for both correctional employees and state mental institution employees. So there are no parameters other than a determination of incapacity for firefighters. And the way that the bill is drafted and presented, there is no limitation on a determination of incapacity based on what might have caused that incapacity for the language related to correctional employees. There's the limitation is only specific to employees of a state mental health institute with regard to infectious disease or assault. So if the committee is, so that I was raising that as a distinction. So I think the committee might, if you wanted to treat these employees like firefighters are under the current law, then it would just be on the basis of incapacity. And if there was an incapacity for a firefighter or these additional employees, their compensation would date back, would start on the date of their incapacity. The waiting period of 7 days would not apply.
So I see you, Representative Geer, Representative Cuddy, Chair Hickman, but I'm going to allow Senator Miramont to answer that question, or do you need time to think about it, Senator?
No, I don't. I believe that was the third. I just, from memory, couldn't jump back to it referencing county. So yes, eliminate that exemption to make it fair. When they can't work, they need to be paid. That I've never understood that part anyway. And the other might be that if it's a declared pandemic or there's an emergency order in place, might be what raises the level of infectious disease to one that requires this to trigger this bill. I'd be up for that too, but I'll give time for the sponsor to work with the analyst if that's what you'd like. But removing that language would be the third part of the amendment that I would want us to vote on now. Please.
Representative Cuddy, you were the second. Do you agree with that amendment?
Yes.
Okay, then I'm going to go to Representative Geer.
And I just wanted to ask Ms. McCarthy-Reed, I swear I'm remembering something where there was a term that was substituted in another statute for infectious disease. And maybe I'm totally misremembering something, but I thought that we had something we were going to go to replace that language, but maybe I'm.
We did talk about the definition of infectious disease when we talked about Representative Pebworth's bill LD 997. But the committee ultimately, and the definition in this bill and in her bill is the same. And so I had raised the question about the broad definition, and as Senator Hickman, I think, mentioned, it would potentially include, any type of virus or bacterial, illness. So I think that's maybe what you're remembering is our
That's
discussion
it.
about
Thank
that.
you.
Mhm.
Yeah.
Representative Cuddy.
Thank you, Mr. Chair. I was wondering if around this idea of the infectious disease and what might be covered, if Mr. Rhodey is available, if we could ask him about this. And my specific question about it is any infectious disease, and perhaps I'm missing something in the bill, and if I am, somebody please correct me. But any infectious disease that you're going to be compensated for, you're going to need to be. It would need to be either shown that it was something that is a work-related injury in order for workers' compensation to cover it, or if it's something that's covered by a presumption, then you'd have to show that it wasn't, I guess, on the other side. So I don't know if I am misrepresenting how that works.
No, I think you're right, but why don't we bring Mr. Rhodey forward? Welcome, Director Rhodey.
Thank you. And you are correct, Representative Cuddy. If just this bill passed amending the waiting period, now you have to have, as you've mentioned, a compensable claim. So whatever injury you have has to be determined to be related to work, and then you have to lose time from work because of that injury before you're entitled to any payment. So yes, this language would just limit which types of injuries for the mental health institute workers would be eligible to skip the waiting period, but they'd still have to prove it was related to work.
Can I get a follow-up, Mr. Chair?
Of course.
So if someone were to claim under, they got sick and they said, no, this is a compensable claim because infectious disease is covered, would they start getting, if this bill were to pass, would they start getting paid immediately? And then you'd have to figure out whether or not they should have gotten paid. And so they may have to pay back?
Nope, I wouldn't read it that way. So let's say it's me who has alleged an injury related to an infectious disease. I report it to my employer. My employer doesn't think I got it at work. What they would do in our system is file a notice of controversy saying, we don't think your injury is related. And then we would go through the dispute resolution process and either resolve it informally or ultimately at a formal hearing later on down the line, at which point I would then be paid.
Right. I'm sorry. I forgot what the change in this bill is. It's that if you go back to work before the 7 days, like right now, if you go back to work for 7 days, you can't get compensated. This bill would make it so you could.
Correct.
If you could be okay.
Yeah.
Thank you.
You're welcome.
Thank you, Director Rhodey. Chair Hickman.
So yes, I was trying to find testimony on the bill, and for some reason my computer won't let me do that. And I do remember that there was someone, I believe, who testified either in favor or neither for nor against that had an issue just with including infectious disease in this bill at this time. And the more I'm thinking about it, I actually think that if we have to prove that the disease was acquired while a person was on the job, it would seem to me the first narrowing language we would need is contagious disease, because Lyme disease is an infectious disease as well, but I don't believe it's contagious human to human. I could be wrong, but I don't think so. So you can't really you could get Lyme disease on a job when you get a tick if you're in the field, but so that doesn't mean it wouldn't be a part of this. So I guess we just really need to know what it is we are asking workers' compensation to cover. And I don't know if it's the best idea to include this in this bill, but I'm just putting that out there for discussion.
The motion on the floor currently does consider it. Representative Bradstreet.
Yes, thank you. I think Mr. Rhodey was here. I noticed in one of the people opposing the bill that it states that this would create a, maybe a start of something with other groups would be going back and trying to reconfigure their waiting periods. And I know we just did get done comprehensive overview of the Workers' Comp Commission, the whole system. And first of all, I wonder how many other groups might be tempted to want to come back and request a more favorable situation. And secondly, isn't it really too early to start undoing what we did last session? So I'll be voting against the bill. I guess that's what I'm saying, Mr. Chair.
Thank you, Representative Bradstreet. Is there any further discussion? Seeing none. Ms. Thompson, if you would call the roll.
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin. Senator Guerin is absent. Senator Miramont.
Yay.
Miramont, yay. Representative Sylvester.
Yay.
Sylvester, yay. Representative Bradstreet.
No.
Bradstreet, no. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
Nay.
Drinkwater, nay. Representative Gear.
Yes.
Gear, yes. Representative Morris.
No.
Morris, no. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott.
No.
Prescott, no. Representative Rader is absent. Representative Warren.
Yes.
Warren, yes.
And Senator Guerin just entered. I just let her in.
Oh, perfect.
We'll wait for her to turn on her camera.
Are you voting?
We are. The motion ought to pass on LD 1430 about an act regarding the waiting period for compensation for incapacity to work under the Maine Compensations Act. Representative Brian Sprill.
Just making sure it was the same one before I had to restart. And I would be.
We missed you at the end there, Senator Guerin. We couldn't hear you at the end, or at least I couldn't.
Nay.
Thank you.
Guerin, nay. That is 7 in favor and 5 against.
The roll being 7 in favor and 5 against, the motion carries. And I will close the work session on LD 1430. Thank you, Representative Bryan, for being here today.
Thank you. And I'll let you know that Representative Drinkwater and I graduated from the same high school, prep school, if you can believe it or not. But thank you.
1996 was a long time ago, Representative Bryan.
Easy now, easy. Thanks.
All right, thank you. And we bring forward Representative Harnett. Welcome, Representative.
Thank you, Representative Sylvester.
And I would open the work session on LD 965, an act concerning non-disclosure agreements in employment. Mr. Langland, if you could give us the analysis.
So this bill prohibits an employer from requiring an employee, intern, or applicant for employment to enter into a contract or agreement that waives or limits any right to report or discuss discrimination, retaliation, or harassment occurring in the workplace or at work-related events. It also prohibits an employer from requiring an employee, intern, or applicant for employment to enter into a settlement, separation, or severance agreement that limits an individual's right to report, testify, or provide evidence to a federal or state agency that enforces employment or discrimination laws, prevents an individual from testifying or providing evidence in federal and state court proceedings in response to legal process, or prohibits an individual from reporting conduct to a law enforcement agency. This bill allows a settlement, separation, or severance agreement under certain circumstances to include a provision that prevents the subsequent disclosure of factual information relating to a claim of discrimination, retaliation, or harassment. It provides the Department of Labor with the duty to enforce these provisions and allows an individual to receive liquidated damages or to be employed or reinstated with back wages, when an employer discharges or refuses to hire an individual who declines to enter into a contract or agreement that waives or limits any right to report or discuss discrimination, retaliation, or harassment occurring in the workplace or at work-related events. This bill is the exact amendment that was reported out of this committee in the 129th legislature by a majority, ought to pass as amended, and a minority ought not to pass. In terms of testimony, the department submitted only written testimony in opposition, saying the public interest is better served by preserving the option of NDAs rather than legislatively restricting the terms and conditions upon which parties can resolve employment disputes. The department also testified that an increase in inquiries may require additional staffing. The Maine Chamber of Commerce testified that it's skeptical that the prohibition on agreements in the bill are actually a problem, and they also questioned whether it's legitimate public policy to create impediments to legitimate dispute resolution. Representative Harnett, in his testimony, testified that all persons are entitled to work in a workplace that is free from discrimination and harassment. No person should ever be placed in the position of waiving these fundamental rights to speak out about workplace harassment and discrimination in order to obtain or continue their employment. And he also said in his testimony that the price of mandatory NDAs means that nearly every civil rights case that is privately settled comes with a muzzle, which has an impact not only on the individual, but on greater public policy. There were a plethora of proposed amendments at the public hearing. From the Maine Employment Lawyers Association, they recommended adding language to clarify that attempts to enforce an NDA are illegal. They also recommended adding a new subsection to provide that nothing herein shall limit an individual's ability to exercise any rights the individual has under federal, state, or local labor laws to engage in concerted activities with other workers for the purposes of collective bargaining or mutual aid and protection. And they also recommended that the bill add reporting requirements. They recommend that each employer with settled a claim of harassment, discrimination, or retaliation be required to report to the Maine Human Rights Commission the amount of any settlement. They also propose that the commission be charged with compiling an annual report of such settlements. And I provided a link to the testimony in my bill analysis. It has examples of reporting requirements that are on the books in other states. The Disability Rights of Maine proposed adding language to prohibit the use of no rehire clauses in settlement agreements. The National Women's Law Center proposed several amendments to the bill. One of them is adding independent contractors, volunteers, and former employees to the list of those included in the law. The National Women's Law Center also recommended the bill should afford individuals adequate time to review the non-disclosure agreement and the opportunity to obtain the advice of an attorney. They noted that New York state law provides that a complainant first must be given 21 days to consider the term or condition of the non-disclosure agreement, and then at least 7 days following the execution of the agreement to revoke the agreement. They also recommended that when a victim of workplace harassment or discrimination agrees to keep the resolution of a claim confidential, the worker should receive some meaningful benefit, economic or otherwise, in exchange in addition to anything of value to which the individual is already entitled. They also recommended allowing victims of discrimination and harassment to withdraw from NDA without financial penalties. They also recommended allowing for a private right of action to recover damages, civil penalties, and attorney's fees if victim of worker rights violations is forced to sign an unlawful NDA or the employer seeks to enforce such an NDA against the victim. They also recommended ensuring that NDAs do not limit an individual's ability to access justice or basic necessities. Encourage the legislature to also require that such a disclaimer note that individuals retain the right to report a crime to law enforcement and to participate in collective action to address workplace violations. And they also recommended that the bill be strengthened to extend protections against NDAs to other employment and labor law violations, such as wage and hour laws. I did include a little bit of statutes that I thought would be helpful for the committee's consideration of the bill, specifically parts of the Maine Human Rights Act for your viewing pleasure. I would also note the committee has not yet received a preliminary fiscal impact statement. However, there was one that was reported out with LD 1259 last session, and I did link to that in my testimony. I'm happy to try to answer any questions. I understand also that somebody from the Maine Human Rights Commission is here, and they might be able to provide further information about discrimination, harassment, and retaliation as well.
Thank you, Mr. Langley. Do you remember what the fiscal note was from last year?
I can look that up right now.
If you look that up, I think that would be helpful. Thank you.
So
yeah,
I
go
can
ahead.
tell you right now, actually. So there was one required, a minor cost increase to the general fund, minor revenue increase to the general fund, and a minor revenue increase in other special revenue funds. The fiscal note said it might increase the number of civil suits filed in the court system. The additional workload associated with the minimal number of new cases filed in the court system does not require additional funding at this time. And the collection of additional filing fees and fine revenue may increase general fund and other dedicated revenue by minor amounts.
Thank you. I wonder if Representative Harnett could come forward.
I'm available, Representative Sylvester.
Good to see you, Representative Harnett. So we have just heard a whole other bill's worth of amendments proposed, and I'm wondering whether you as the sponsor have any amendments out of that list that you're hoping to put in, or if you're hoping we will review your bill as is.
I am comfortable with the bill as is. I think some of the amendments suggested are worthy of consideration, but they're not what I'm trying to accomplish right at this point. Extending it to other violations of wage and hour laws takes it beyond what I was looking at, which was discrimination in the workplace. So I welcome the input of those who suggested the amendments, but it's not what I'm looking for right at this moment.
Thank you very much. Mr. Langland, there was some information that I had asked from the Maine Human Rights Commission. Did they send that forward, or?
I did not reach out to them with anything. Perhaps I missed your requested information, but I know, like I said, I know that there is someone here. If you have it, they might be able to answer it actually on the spot. But
Yep, with the indulgence of the committee, if I could call the Maine Human Rights Commission forward. Amy, Ms. Nearson. Welcome.
Good afternoon. Hi, I'm Amy Sneerson, the Executive Director of the Maine Human Rights Commission. I'd be glad to offer any information that I can. I don't recall there being a specific question I was asked to give information about.
I guess whether or not you saw this as in any way impugning on the Maine Human Rights Commission, or whether or not you think this is that this law stands separately in the protections that the Maine Human Rights Commission already offers.
I will tell you that I have not studied this tremendously closely, but my understanding is that it's a part, and it's going to affect some cases that are pending with the Maine Human Rights Commission, and whether they resolve or not. I think it might have an impact on how many cases resolve, but it might not, and it might impact cases that never come to our agency.
Okay, thank you very much. There had been an issue raised with me about whether there was a conflict, so I just wanted to clarify that. So I appreciate that.
Yeah, I don't see a conflict.
All right, perfect. Thank you. Is there any discussion from the committee? Oh, I think Senator Hickman has a question for Ms. Sneerson.
Yes, if I can get it formulated. Director Sneerson, first, thank you for being here. How frequently does it happen, if it happens at all, that a person resolving an employment dispute signed an NDA, but also wants to proceed to your agency to file a complaint?
That's a really good question. We do receive, I would say, a handful of complaints each year where we get an immediate response from the employer saying this should be dismissed immediately because the person who filed the complaint signed an agreement that contained a waiver and a non-disclosure agreement. So they don't even have standing to bring this complaint to you. So it does happen, I would say, a handful of times a year.
Thank you.
Is there any further discussion? Senator Mearmont.
Thank you, Mr. Chair. I make a motion not to pass.
The motion is ought to pass. Is there a second? Representative Geer? Seconds? Is there any further discussion? Seeing none. Ms. Thompson, if you call the roll.
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin.
Nay.
Guerin, nay. Senator Miramont.
Yay.
Miramont, yay. Representative Sylvester.
Yay.
Sylvester, yay. Representative Bradstreet.
No.
Bradstreet, no. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
Nay.
Drinkwater, nay. Representative Gear.
Yes.
Gear, yes. Representative Morris.
No.
Morris, no. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott.
No.
Prescott, no. Representative Rader is absent. Representative Warren.
Yes.
Warren, yes. That is 7-5 with 1 absent.
You're on mute, Mr. Chair.
I was going to sing it, but since I was on mute, now I'll just say it. The motion, have it being 7-5, the motion carries, and I would close the work session on LD 965 and thank Mr. Representative Harnett for sticking around, because we are going to now open the work session on LD 1489.
Oh, wait a minute, Mr. Chair.
Yes, Mr. Chair.
I believe Harnett has one more bill in front of us today. Am I incorrect?
Yes, and that's about what I'm about to open.
Oh, okay. You said 1489. So I just wanted to make sure.
I just wrote it down wrong. So
Okay.
I of course meant 1461, and luckily I had not swung my Sea Dog's bat yet. So let's open the hearing on LD 1461, an act relating to heat illness prevention. Mr. Langland.
Before I begin, can I just clarify what the minority report of the last vote was?
Ought not to pass.
Wanted to make. Share my screen with you. So this bill requires the Department of Labor to develop a safety and education training program for employers, supervisors, and employees addressing heat illness prevention, and requires the department to make the training available on the department's publicly accessible website by December 31st of this year. It requires the department to adopt rules for the implementation of the heat illness prevention training program. It requires an employer who requires an employee to work in a high heat environment for more than 15 minutes for every hour of the employee's workday to provide annual heat illness prevention training to the employer's employees and supervisors, to make the training and all relevant materials available to the employee or supervisor upon request, and to provide the training to any new employee working in a high heat environment and to a supervisor before the supervisor may supervise an employee working in a high heat environment. And it also requires an employer to take the following heat illness prevention measures: provide readily accessible drinking water to an employee working in a high heat environment, remove an employee exhibiting mild to moderate signs or symptoms of heat illness to a cooling area for 15 minutes, and if the signs or symptoms do not abate, seek medical attention or administer first aid. If the temperature is 80 degrees Fahrenheit or greater, maintain one or more cooling areas sufficient to enable employees to participate in recovery periods. And if the temperature is 90 degrees or greater, ensure that an employee working in a high heat environment is able to easily communicate by voice, gesture, or electronic means with an employer or supervisor, so that the employee may report signs or symptoms of heat illness or request emergency medical services. Regularly remind the employee to consume drinking water. Ensure the employee takes 1 10-minute break for every 2 hours spent working in a high heat environment, and review these measures with the employee before the employee begins working in a high heat environment. There was testimony from the public hearing that the definition of high heat environment is not clear, and I've included that in the box. There was also testimony from the public hearing that the phrase in the definition of environmental risk factors for health illness that reads, "that has the possibility of heat illness," is too broad. There was also testimony from the public hearing that subsection 3, paragraph B, subparagraph 2, would require an employer to seek medical attention for an employee, even if that employee refuses. The department submitted written testimony that said the department's workplace safety and health division can and will develop the proposed heat illness prevention training with or without this legislation. It noted, however, it does lack enforcement authority on private businesses due to OSHA. The department plans to issue a non-mandatory compliance directive providing best practices regarding workplace temperatures, such as those identified by the American Society of Heating, Refrigeration, and Air Conditioning Engineer standards. So Maine is an OSHA state plan state, as mentioned above. So this means OSHA has jurisdiction over private businesses and federal government operations here in the state of Maine. The state's Board of Occupational Safety and Health has jurisdiction over state and local government workers. There was testimony that discussed the OSHA Act of 1970 and its general duties clause, which does read that each employer shall furnish to each of his employees employment in a place of employment which are free from recognized hazards that are causing or are likely to cause death or serious physical harm to his employees. Committee requests for information. I think there was discussion about Mr. Rowland from the Department of Labor explaining OSHA's state plan again to the committee. And I did include a link that has more information on the state plan. And there was discussion at the public hearing that OSHA itself has a heat illness prevention campaign that was started in 2011. I included that link in my bill analysis as well. And there was discussion about the Department of Health and Human Services having a website on heat-related illness, and I included that in my bill analysis as well. We have not yet received a preliminary fiscal impact statement.
Thank you, Mr. Langland. Is there any discussion from the committee? Seeing none, what is the will of the committee? Senator Marymount.
Well, I just don't, I don't like that it leaves out so many workers. I think it's something to address. I think we need to review it. And we talked about that in the other bill, but I don't think this took me further than the other bill. So I have to move it ought not to pass.
The motion is ought not to pass. Is there a second? Seconded by Representative Drinkwater. Is there any further discussion? Chair Hickman.
Thank you, Mr. Chair. Obviously, I love the bill sponsor and wish that I could vote for this bill, but it doesn't have the enforcement teeth in it. And we do need to deal with this issue. And I think that heat prevention, illness, education, what to look for is going to be an important step forward. And maybe we can revisit something more powerful and enforceable later. But if we are an OSHA state plan state, I mean, for our public employees, of course, we could do this, but not for our private employees. And so I will support the motion today. Thank you.
Thank you, Mr. Chair. Is there any further discussion? Seeing none, Ms. Thompson, if you could take the roll.
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin.
Yay.
Guerin, yay. Senator Marymount.
Yay.
Marymount, yay. Representative Sylvester.
Yay.
Sylvester, yay. Representative Bradstreet.
Yes.
Bradstreet, yes. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
Yay.
Drinkwater, yay. Representative Gear.
Yes.
Gear, yes. Representative Morris.
Yes.
Yes. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott is absent. Representative Rader.
Yes.
Rader, yes. And Representative Warren.
Yes. Yes.
Warren, yes. That
Yes.
is unanimous of those present.
The vote being unanimous of those present, the motion carries, and that closes the work session on LD 1465. We thank the sponsor for being with us here today. We only have one more bill that is a non-committee bill. It's by Representative O'Connell. Alyssa, do we see Representative O'Connell? I'm not seeing him.
No, I don't see him either.
So I would put forward to the committee, it is 5 o'clock. We can keep plowing forward as we are, or we can, since the bills that are left are a representative who's not currently here and folks who are here regularly for committee anyway, would we like to call it a day at 5 o'clock? Hi, Representative Geiger, how are you?
Good.
I don't see a bill posted for work session today for you. I had asked Alyssa to ask if you were here on support of another bill.
No, I was here for, I understood that my bill was tabled on Friday and the work session would be today. And I received a link this morning from Alyssa Thompson.
I apologize. I sent you one assuming you were the co-sponsor for one of the bills. That, yeah.
Okay.
Sorry, Representative Geiger. We appreciate your being here for emotional support today. And I will make sure to call you personally when we schedule your bill.
Thank you so much. I'm very impressed with the scope and depth of the things that you are hearing today. So it was very instructive.
Well, we'll have to just drop in on one of your committees for hearings for no reason. But thank you for being here. We appreciate you. So what is the will of the committee? Do we want to put off the bills that are on the session? Representative Cuddy?
I find 5 o'clock to be just a fantastic time to knock off for the day. So I understand we have a lot of work to do, and it could be that I got my second Pfizer dose on Saturday and there's a little tail end of that, but I find myself flagging.
I think we have certainly had a full day. Is there anyone opposed to putting the bills aside that are committee bills and a missing sponsor so he can be here? Seeing no opposition, and I will call that. Yes, Mr. Chair.
I just want to let folks who are listening in for the first time know that this was what we discussed earlier, that we would allow the committee to decide how late we would work as we try to meet our deadlines as put down by our presiding officers. I just wanted people to know that even though we advertise these work sessions, if they didn't hear, that there are going to be some flexibility around that.
Yes, and I would like to say that, you know, one of our goals is to make sure that we have a full day of work. I think we met that goal today, and you know, and so I appreciate the committee's work. I appreciate everyone who is in attendance, but I will call this meeting of the Labor and Housing Committee adjourned. Oh, Representative Bradstreet, before I hit my.
Yeah, just a quick question. Are we going to be meeting other days other than Wednesday and Friday this week?
Not this week, sir.
Okay. Thank you.
Yep, thank you. We're still waiting for some bills to process through, but we expect that we will be concluding most of our work this week and then hearing work sessions on the things we heard next week. With that, I adjourn the committee. Have a good